If we were just waiting for the legal process to start, it's too late. If you're waiting for trial, you're not going to be happy.
Is that driving more people to alternative resolutions then because they're seeing kind of potential outcomes or negative outcomes for them that are much worse than they used to be?
You want to go to trial? The attitude is first you got to try to mediate this.
What's the percentage?
A very high. I've read statistics as high as 80 to 90% of cases are not going to trial because of mediation.
Welcome back to the Search Bar, everyone, the podcast for law firm leaders who want smarter growth without the guesswork. Wine optional. I'm Eric Ritter, the SEO sommelier and founder of Digital Neighbor. With more than 12 years of experience helping law firms scale, I'm here to have insightful conversations with industry subject matter experts so you can learn from them. And if you're ready to dominate in today's AI-driven search environment, check out my Motion for Marketing Success System. It starts with a free discovery session, no fluff, just a clear path forward. The link's going to be in the show notes. And I'm very excited for today's episode, so I want to get right into it. We're looking at the heavy toll of prolonged litigation and friction within the business world. We're going to dive into how alternative dispute resolution can actually save companies millions, protect corporate reputations, and clear backlogged court dockets before a single juror is ever selected. To help kind of break that down today and the mechanics of settlement, I am joined by Larry Rute. Larry is the managing partner of Associates in Dispute Resolution, ADR. He brings over 27 years of experience as a powerhouse civil litigator and more than 40 years as an arbiter and mediator, having successfully guided over 4,000 complex matters to a resolution. Larry, welcome to the Search Bar.
Thanks so much. I really appreciate the opportunity to say hello to everybody.
Awesome. Well, we're looking forward to our conversation. Before we get into it, as you know, I call myself the SEO sommelier, and I always look for a wine that tells a story. And I learned that you keep a great bottle of Cabernet Sauvignon in your office for parties to open and celebrate after a successful settlement. And I think that's incredibly fitting. It's a bold Cabernet, requires patience, structure, and time to soften those harsh edges, much like the mediation process of itself. So it's really the perfect wine to toast to common ground.
Thank you very much. We use it for, or at least make that offer at the end of a face-to-face mediation. And anymore, I think our audience knows a lot of the mediations are via Zoom or via some other methodology that are not face-to-face. And so, all I can do is wave the bottle in front of the screen and hope that they enjoy it.
Make a recommendation there. I love that. Awesome. Cool. Well, let's get into it a little bit here. So, having a subject matter expert like yourself, definitely want to pick your brain a little bit. Especially when it comes to kind of how people see the courthouse a lot of times the only venue for a true resolution, but state and federal courts, we all know it, are increasingly relying on neutrals to stop fights before they actually escalate into a trial. So I'm just curious, how are state and federal courts utilizing mediation to actually resolve matters prior to trial? Just to kind of start out here, Larry.
First time I was involved with court-ordered mediation, I was litigating a class action in the Western District of Missouri, which is in the Kansas City region. And I was notified that they had set up a new program in 1989, or maybe it was 1990, that they were going to send some cases to mediation before trial. And I'd actually had received a little mediation training, both in family law and also in commercial law, but I hadn't used it. Not something that it was just something I was using to train my associate attorneys and so forth, and getting them ready for the future. So when the Western District of Missouri offered this, at first, I kind of smiled. I thought, "Well, this isn't going to work." I'm used to. I've got a court date. I'm ready to go in and and try to do some damage to the other side. And but they asked me, Kent Snap was their first director at the Western District, and he called me and said, "Will you consider this mediation?" And we did, and we settled a case that, you know, personally, as a litigator, I thought would be impossible to settle, and, that really brought me around. I was just absolutely floored. It took us a couple of days because it was a big case, but I found that whether it's a big case or a small case, occasionally, in fact, often mediation or some other dispute resolution method would be helpful. And so that's how I got started way back then. I litigated for 27 years. You wind me up, you put me in a courtroom, I've got something to say, you know. It may not be the right thing, but I'm there. And then I received a contract through an organization I was working with from the Kansas Human Rights Commission to do employment discrimination mediations. And I hired three other mediators, one non-attorney and two attorneys. I wanted to see whether non-attorneys could work in that venue or not, and that are trained mediators. And mediator training takes about, well, initially usually about 40 hours of training, and then we do co-mediations. I often have a co-mediator with me during a mediation that I'm training. In Kansas, for example, the Supreme Court wants um, uh, uh, those who are seeking mediator approval to have at least three co-mediations with an experienced trainer so that they hopefully can move into the market and not embarrass themselves. And
Right,
so
right.
we, and so I often bring in co-mediators. It's very helpful, by the way. That's a whole different subject, but you can bring in a subject matter person who has great expertise in an area. I brought in an attorney the other day in in a real estate case. Well, I handle real estate work, but I'm not claimed to be an expert. But this person really understood the ins and outs of real estate law and was very, very helpful to joining me in that mediation. And it made it a lot faster. I'd like to move the mediations as quickly as I possibly can. So, in any event, that's how I got started handling these for the Kansas Human Rights Commission, and then finally for EEOC in Kansas and Missouri, I started handling some of those cases as a mediator, and finally just opened up. I had an old friend who was a judge in Shawnee County, Kansas, who was retiring, and said, "Well, just open up a law firm. We do nothing but mediation and arbitration." And I told him, "Well, I don't know if I have any interest in arbitration, but if you'll go to Pepperdine and get your training as a mediator, and go with me on some mediations, so I know that we'll work well together. I'll go to arbitration school in Chicago and become an arbitrator." And that's what we did. We opened up a practice, and we've always had a panel of mediators that they're up and coming people or people that are well established that we can move into any kind of commercial environment. Uh, whether it could be nearly anything, and I have somebody that's worked in that venue before. So uh,
Nice.
I know you have questions, but I wanted to at least give you
No.
that background.
No, that's fantastic, and kinda hearing you talk, Larry, as a former litigator, I'm just curious, you've been doing this for a while, what maybe is the biggest misconception or even maybe misconceptions trial attorneys, litigators still hold today, when they think of a mediator's role when it comes to, like you mentioned, a high stakes commercial dispute there?
Well, what we have to do as litigators, and I had to learn this in my first mediation as a participant in mediation, is to drop my aggressive litigator style. And to do that, you got to explain to your client, "Hey, I'm going to take on a different role here. I'm trying to find a way that we can settle this case. I'm not going to be pounding the table and attacking the other side. I'm going to try to find a place where maybe we can find some resolution." And so my role as a litigator is totally different in mediation than it is in litigation. And as we prepare for jury trial, we have to understand sometimes there's certain things you just don't wanna well, you don't wanna push too hard with a jury. Maybe you have a vulnerable witness or something. It's the same thing with mediation. You want to just, uh, be more resourceful in the way that you handle your arguments so that you can maybe bring the other side around.
Makes a lot of sense. So I want to move on to mediation and arbitration, right? You already kind of
Mhm.
mentioned both there.
Yeah.
And yeah, I just want to clarify that playbook when it comes to one or the other. Just, if you could just share with the audience briefly kind of your definition of what the difference between a mediation and arbitration is, maybe how that playbook is different.
And I'm gonna spare you from the, law school definition of these. I'm gonna take it more in a practical way. I
Yeah.
I did teach, dispute resolution at Washburn Law for 8 years, and I can be I can be very precise if you want me to be, but I think of it as a different thing.
Yeah.
When I'm asked by someone, "Tell me the difference between arbitration, mediation," when I mention arbitration, I say, "Well, you've seen Judge Judy on TV. Judge Judy has a case before her. People stand up and present their case, and at the end of the day, she comes up with a decision. She's an arbitrator, in effect, uh,
Yeah.
or a
Yeah.
private judge, but that's arbitration, where uh, that person makes the decision. With mediation, our role as mediators, and I'm an attorney mediator, is not to make the decision, but to help both sides make the decision. And we use different techniques to do that. We reflect, and reframe the problem. We do a little reality testing. We try to manage emotions because I used to handle family law cases, and managing emotions is the key thing you have to do
Right.
if you're
Absolutely.
managing a
Wow.
family law
Yeah.
case.
Yeah.
You have to manage their expectations of what the parties can really achieve through the process and through court. Um, and so there's a lot of different things that a lot of different schools were using active listening skills to really I like to talk to the co to if there's a plaintiff, I wanna talk to the plaintiff and just find out what makes that person tick. If I'm talking to the insurance adjuster, I wanna try to find out a little bit about, how they understand this case and where they think it's going. And so I as a mediator, I wanna talk to the attorneys, but I particularly wanna talk to the participants and try to find out where they're at and then help them get maybe the direction they wanna go.
Interesting. No, that's so interesting. One thing that I've always thought about, we're kind of shifting gears to the mediation side of it. Um, and kind of with the litigators kind of hat and mind on, do you ever get into situations where maybe that whole mediation session, it just completely is just exists there because the other side wants to maybe see the strategy before trial, right? And just want to see what cards you kind of have there. How do you handle, someone who's really just completely, going in with it with bad faith?
Well, when I was first starting to mediate seriously in 2001, when I first moved into a full-time mediation practice, um, things were quite a bit different. At least in my region, attorneys wanted to do opening statements where they wanted to pound the table and tell the other side what a wonderful case they had. And I have slowly, uh, disengaged from that sort of practice. And I'll tell you how we do that in a moment. But the, uh, uh, the other thing that happens is that well, I think I will take a tell you kind of how we set up a mediation because it's an important thing. Before a mediation, if I before a commercial mediation or if I were still doing a family law mediation, I want to speak to the parties separately before we meet. So it's a form of mediation preparation. In terms of commercial mediation, we certainly want position statements from the parties if the petitioner or if the plaintiff has filed a complaint or a petition, I want to see the complaint and petition. I'd like to see their analysis of it. I want a position paper from the other side. But what I'll do And what a lot of mediators do is call the attorneys in advance privately and say, we want to, tell me a little bit about the case. Give me the 5-minute drill, what this case is about. Sometimes I can learn a lot more with a 5-minute drill than I can with all the documents that
Right,
they've
yeah, if
sent
you
to
actually are
me.
forced to get the key facts
Yeah,
out
that's the
succinctly.
elevator conversation about your
Yeah,
case,
yeah,
you know?
yeah,
I don't tell them I'm doing that, but
yeah,
that's what I'm doing. I also wanna
right,
make sure the right people are in the room, because early on, and when I first started, insurance was involved on the defense side, but they were never in the room. I never had contact with them other than maybe through a cell phone. So, trying to make sure that we have really, the decision makers available and ready to go and understanding of the case before we start. So my preparation for mediation, whether it's family or whether it's commercial, and primarily I do 99% commercial, but I do division of assets cases for families, and uh, those are very emotional. You're talking about the kids, you're talking about the house, you're talking about the
right,
finances. That's something that, that's what a real mediator does, I think, is work with those emotions. And but in any event, so before the mediation ever starts, I have a lot of information, and I'm probing. I may have a couple of conversations. In class action mediation, or collective action mediation, I like to have the attorneys meet with me on Zoom, either together or individually, because I want to make sure the right data is available in advance of the mediation. Otherwise, we're wasting our time. Um, my friends at the Western District of Missouri, for example, send over class action cases almost within 120 days of when they're filed. We don't have enough information yet to know what kind of a case it is, or do we have subclasses? Do we have, what are the allegations? So we have to I like to meet with the attorneys and make sure we have as much information as humanly possible in advance of the mediation, so we're not wasting our time.
right, yeah, that
I
makes
hope that
sense.
answered your question.
It does, yeah, so, I mean, essentially, you wanna do as much homework ahead of time to understand kind of what's the kind of goal or objective of each side here and making sure they're not coming in bad faith.
I'm old school. I walk in with my little pad of paper with a timeline and what happened when and who did that and why did they do that?
Yeah.
I'm ready to go.
Yeah, no, that makes so much sense. Awesome. So I want to talk a little bit about conflict that doesn't just happen between companies, right? It
Mhm.
happens inside them. So
Yes,
designing a system that catches kind of maybe that internal corporate friction early is what a lot of times separates businesses that survive from ones that actually thrive. So, wonder if you
absolutely.
could walk us through the concept of conflict system design and how maybe because I was obviously did my homework a little bit as well, Larry. I saw you have a multidisciplinary approach that helps resolve those deep-seated corporate issues. Just curious, if that includes mediation, arbitration, and internal dispute resolution there.
Well, as an aside, I know you well enough now. I know you do your homework, so I'm not I'm not at all concerned that you. This is an interesting area of dispute resolution law. I
Yeah.
first became aware of it. I used to be a fairly active member of the American Bar Associate's dispute resolution section, and the section began working in 2011 on dispute resolution design systems and what they were trying to do is cut down the cost of court. What can we do? These court proceedings are becoming more and more expensive. The use of experts is much more pervasive, very expensive to bring in these experts. Uh, and what do we do to try to mitigate where not so many of these matters are going to trial? And of course, as now a mediator, one of my suggestions, and well, actually, the head of that was John Landy, who of that task force section, who is a eminent professor at the University of Missouri, they have their own LLM in dispute resolution at the law school. A very active program. He's web he John Landy is very well known in dispute resolution circles and his colleagues. And he he helped put together a plan that companies could use internally to reduce conflict before it happens. And the reason that is we have so many employment discrimination cases being filed. You know, there's a plethora of discrimination that can be filed, whether it's age or race or gender or ADA or what we can go down the list. But those cases come through the business, charges filed with EEOC. That may be the first time the organization even knew they had a problem is when the EEOC charge comes. And by that time, that employee, uh, uh, the opportunity to work with that employee may be gone. So what John Landy and the task force put together was why don't corporate and of course corporations have been doing this for a while. Long before the task force, Coca-Cola, um, corporations like Hallmark had developed their own internal dispute resolution programs. And what that meant was they had a very that these were streamlined to meet the needs of that particular business. They had identified, for example, they were perhaps getting too many employment discrimination cases popping out of the workforce. And so, what are we going to do about that? How can we mitigate that before? How can we resolve those problems and have a happier workforce and a more productive workforce?
Right.
Because these sort of complaints are very destructive. And you know, you drag then when you go to trial, then you're dragging in that workforce and you're dragging in those managers, and it's trauma for the corporate environment. And so what the task force basically suggested that corporations provided either go outside and find someone or through their own resources do an analysis of what are the conflicts they're having in the workplace. How severe are they? How long lasting? How intense are they? Um, uh, what should we do about this once we become aware of it? So you do this survey, and it needs to be, and if you're gonna do an employment, if you're going to have a dispute resolution program, it needs to be bought into by the highest management, but also at the lowest employee level. It needs to be support from the top to the bottom and the bottom from the top. It can't just be imposed by the employees.
Yeah.
It requires a discussion. What do we need to do? Do we need to put together peer review systems? Do we need to establish an ombudsman? Do we need to have an open door policy? Do we need to have someone that comes in and does some fact finding or do a neutral evaluation of what the problem is and try to suggest a solution to it? There's and then ultimately you may want to mediate those claims within the corporate structure. Who does the mediation? It's best to have the mediator be from outside because you want these mediations to be confidential and you want the employee to feel that they're being heard. And if they feel like, well, everything I say just going to go up to management, that's not going to work very well.
Right, right. Yeah.
And as a backstop, if the mediation fails, many employment agreements are now putting in arbitration agreements. And those are not as easy as you might think because they need to be very, very fair. They're going to be overturned by the courts. There's a term of art in the Court of Appeals called mutuality. And what it really means is that arbitration system needs to be fair to both sides, not tilted one way or the other, which means that you have to have neutral arbitrators that don't have a dog in the fight. It is these programs are essential to the corporate workplace, but it also has to be carefully managed.
Lot of complicated moving parts, but it makes a lot of sense, right? If you
Yeah.
look at it from the outside, and it seems like you guys have really mastered that at ADR. And I know that ADR utilizes a unique team. You know, you mentioned earlier former judges, executives, even mental health professionals. So,
Mhm.
why do you think kind of just strictly sticking to the legal side or that approach often isn't enough when it comes to kind of that internal corporate warfare?
Yeah, if we were just waiting for the legal process to start, it's too late. Uh, there needs to be an intervention as early as possible, that would allow the employee to have the opportunity to state what the problem is, to have management understand what that problem is, and see if they cannot correct it through some of these systems that I mentioned. Uh, if you're waiting for that EEOC complaint, you're way too late. And you know, if you're waiting for trial, uh, you're not going to be happy. With the juries on these employment discrimination cases are being much more aggressive the last 5 years, I would say. I don't know whether COVID had something to do with it, but we're seeing much higher jury awards in employment discrimination cases than we had seen previously. And this is both in state court and
Interesting.
in federal court.
Yeah.
And I don't have I'm not a psychologist, I don't know what that's about, but,
Yeah.
those awards are inching up dramatically.
Yeah. That makes a lot of sense, and I was not aware of that. So that wonder is that driving more people to alternative resolutions then because they're seeing kind of potential, outcomes or negative outcomes for them that are much worse than they used to be?
Well, as we started the program, what the courts have done then, uh, and I don't think it had anything necessarily to do with the task force or anything of that sort, but the courts have become they've taken the position both in the state and federal court to mandate mediation at certain stages before trial. You wanna go to trial, the attitude is first you gotta try to mediate this, and try to work this out, and it might take 2 or 3 I just completed a case last week. We mediated it 3 times. It was such a contentious, emotional case, and finally got it done after that the 3rd time, but it helps that the trial was coming up next month, so that puts a little emphasis on
Right.
it.
It's
But,
good to have kind of that
what
deadline
our
or
courts are doing is in their scheduling order, just saying, "Okay, where's your mediation?" Before they may have other sanctions. They may not allow you to do certain discovery until you get your mediation out of the way. They may delay on dispositive motions or sending matters to trial. There's a lot of different ways the courts deal with it, but basically they're saying you go work this out or try to work this out first and then move on. And a lot of them do. I mean, we're high percentage of cases are resolved through mediation.
really say that again, what's the percentage?
A very high, the I've read, statistics as high as 80 to 90% of the
Wow.
cases are not going to trial because of mediation. Now,
That's fantastic,
it
yeah.
depends on the region and it depends on who's
Sure,
reporting,
sure.
and you gotta be careful about how mediators report these things, so you take it with a grain of salt, but,
Sure, sure.
those are some of the statistics we've seen nationally.
Yeah, but either way, I'm sure it doesn't vary that much throughout regions, that
Yeah.
no matter what, that's still a very highly impressive number there. Kinda here coming towards the end, Larry, I'm curious, if you have, any advice maybe for a law firm owner, managing partner listening right now who maybe their law firm is growing rapidly, right? They're managing that growth that's just coming out of
Mhm.
everywhere. Is there maybe a first step that they could take to design a conflict resolution process for their own partnership group?
Absolutely, and law firms are doing that, because it's hard to maintain employees. um, uh, Established people were being poached by other law firms and so forth. And you
Yeah,
need to make sure it's a positive and creative environment and 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 a well-paid environment so that people stay. And so, yes, law firms themselves have set up dispute resolution programs, but also within the we have settlement professionals now that within the law firms that for their clients, my job is to settle the case, and then we have another attorney whose job is to try the case. So
Yeah.
there's that as well as we have a dis we law firms are breaking into distinct functions. Some law firms have their own mediation program, and I don't know, there's a large firm in Kansas City. I always wonder how they go run through all their conflict checks because but they have a very active mediation program, uh, and it's successful, and so it can be managed. It's another source of income for law firms to have a panel of mediators that can handle these cases, maybe on referral from other law firms or directly referral from the public. But uh, uh, things are changing dramatically in the legal sphere, and it has
Yeah.
to.
Right. No, I love that, Larry. And I just want to say thank you so much for sharing all these fantastic insights with us today. I know our listeners, viewers got so much great value out of this because it's really rare for me to speak with someone who's seen really that great evolution in alternative dispute resolution from the very beginning to where it is today. Before we wrap today's episode, can you share maybe where our audience can find more resources on dispute resolution, dispute system design, and how they can connect with you or your team at Associates in Dispute Resolution?
Well, I'm not crazy about this book really 'cause it's kind of, I there is a book, Dispute System Design, that is out there, and I've used that in my classes at law school to break out, and there are checklists of maybe what, uh, what an interview protocol would be in developing an internal system and so forth, and so there are resources like that. The American Bar Association, I would contact I would look at the dispute resolution section's materials on dispute resolution design. I think that would be inexpensive, and it would be in some ways, a quick read rather than reading a tome.
Yeah.
And, uh, but I think the American Bar Association section on dispute resolution is a great resource, and I would encourage people to take a look at it.
Amazing. Well, that was so helpful, Larry. Thank you so much. And for our listeners, if you're ready to scale smarter, not harder, book your free discovery session through our Motion for Marketing Success system. The links can be in the show notes, just like all the other resources that Larry mentioned here. Until next time, stay curious, stay grounded, and keep building a law practice you genuinely love. Thank you so much, and cheers, everyone.